The neighborhood is called Birchwood Terrace, a cluster of vinyl-sided rentals tucked off Highway 13 on the eastern edge of Wisconsin Dells. Population around 2,900 in the off-season. The town survives on water parks and weekend tourists, and most of the year-round residents work in the service industries that keep those parks running: housekeeping, kitchens, maintenance crews. The address on the warrant belongs to one of those workers. A 34-year-old woman the agents know as Maribel C., employed for the last 6 years at a resort laundry off Wisconsin Dells Parkway. She has one outstanding final order of removal, dated September 2019. She also has a son. The file lists him as a U.S.-born minor, age 8, no criminal history, no relevance to the enforcement action beyond his physical presence at the residence. The lead agent on scene is a 15-year veteran out of the ICE Enforcement and Removal Operations Field Office in Milwaukee. He has run more than 400 residential operations across southern Wisconsin. He has a checklist taped to the inside of his clipboard, and item 9 on that checklist reads, in capital letters, "Minors present, confirm care plan." He will later tell investigators he read that line at 4:51 a.m. as the convoy idled at the corner of Oak and Trout Lane. What he does next is the first decision the review board will examine. He gives the green light. The stack moves at 5:03 a.m.
2 agents to the front door, 2 to the rear sliding glass, 1 on the driveway, 1 in the lead SUV monitoring radio traffic. The knock is loud, 3 sharp impacts, the standard cadence, followed by a verbal announcement. "Police, federal agents, open the door." Inside the house, a light snaps on in the back bedroom. A woman's voice calls out in Spanish asking who is there. The agents announce again. 22 seconds pass. The deadbolt turns. Maribel opens the door in a gray sweatshirt and sleep pants. She's barefoot. Behind her, in the hallway, the silhouette of a small boy appears, hair flattened on one side from the pillow, one hand rubbing his eye, the other gripping the doorframe. The lead agent identifies himself, presents the administrative warrant, and tells her she is being detained under Section 1231 of Title 8. She does not resist. She asks, in English, if she can put on shoes. The agent says yes. She asks if she can call her sister. The agent says, not yet. The boy starts crying at 5:06 a.m. For the next 11 minutes, the scene inside the house runs on 2 parallel tracks. On one track, the procedural, handcuffs applied to the front because the subject is compliant, a quick sweep of the residence to confirm no additional occupants, a property inventory started on a tablet. On the other track, a child screaming for his mother, an agent trying to calm him in broken Spanish, a neighbor across the street stepping onto her porch with a phone already recording.
By 5:11 a.m., the entire operation is being live-streamed to a Facebook account with 84 followers. By 7 a.m., that video has 11,000 views. By the end of the week, 9 million. Think about that number for a second. 9 million. The protocol question begins here. ICE Directive 11064.2, issued in 2022 and still active as of the date of this operation, instructs officers to take all reasonable steps to avoid detaining or arresting a parent in the presence of their minor children. The directive does not prohibit it. It requires documentation, a justification entered into the field report, and a confirmed care arrangement before the parent is transported. The lead agent will later say he tried to follow that sequence. The body camera footage, eventually released under FOIA pressure, shows something more complicated. At 5:14 a.m., Maribel gives the agents her sister's phone number. The sister lives in Baraboo, 23 minutes away. An agent calls the number twice.
No answer. He leaves a voicemail. At 5:19 a.m., a second agent suggests they wait for a callback. The lead agent decides they cannot. They have two more addresses on the morning's manifest, both in Sauk County, and the operational window is closing. He calls the field office supervisor. The supervisor authorizes transport of the minor to the local Child Protective Services intake office in Wisconsin Dells, which does not open until 8 a.m.
That 2-hour and 41-minute gap is the second decision the review board will examine. The boy, his name is withheld from public filings, but court documents identify him as J.C., is placed in the back of one of the SUVs alongside his mother. Both are belted in. He is not handcuffed. He is wearing race car pajamas, no jacket, no shoes. An agent grabs a pair of light-up sneakers from the front entryway as they leave. The temperature outside is 41 degrees. The convoy departs the residence at 5:31 a.m. By 6 a.m., the video from the neighbor's porch has been shared into 3 regional immigrant rights Facebook groups. By 6:45, a lawyer in Madison has the case number. By 7:15, the local NBC affiliate is on its way to Birchwood Terrace with a satellite truck. The story moves faster than the convoy does. You might wonder why ICE conducts these operations at dawn at all. The answer is operational, not theatrical. Pre-dawn timing accomplishes 3 things. It reduces the risk of the subject being away from the residence. It cuts the likelihood of crowd interference, and it lets agents clear multiple addresses before the workday begins. On paper, it is the safest window for everyone involved. On paper. The convoy arrives at the Wisconsin Dells Police Department parking lot at 5:47 a.m., where the agents intend to hold position until CPS opens. Maribel is moved into a holding van. The boy stays in the SUV with one agent. He has stopped crying.
He has not spoken in 18 minutes. The agent later writes in his report that the child appeared subdued but cooperative. A clinical psychologist hired by the family's attorney will later describe that same state in the same report as acute dissociative response. 2 phrases for the same silence. At 6:32 a.m., the sister calls back. She is awake. She is driving. She will be at the police department in 26 minutes. The lead agent tells her to come directly. He tells her she will need identification and proof of residence. He does not tell her that the decision to release the boy to her custody is not, strictly speaking, his to make. At 6:58 a.m., the sister arrives. She is 41 years old, a U.S. citizen, a certified nursing assistant at a Baraboo nursing home. She presents her driver's license, her CNA badge, and a utility bill from her apartment. The lead agent calls the field office supervisor. The supervisor calls the Milwaukee Assistant Field Office Director. The decision takes 19 minutes. At 7:17 a.m., the boy is released into his aunt's custody. He has been in federal custody for 2 hours and 14 minutes. His mother is transported to the Dodge Detention Facility in Juneau, Wisconsin, a county jail that contracts with ICE for detention bed space. She arrives at 8:43 a.m. She's processed, photographed, fingerprinted, and assigned to Housing Unit C3. She does not speak to her son for the next 4 days.
The Dodge Detention Facility is one of 3 primary ICE holding sites in Wisconsin, with a contracted capacity of 296 beds at a per diem rate of approximately $92 per detainee. On the morning Maribel arrives, the facility is at 81% capacity. By the end of that same week, after a series of similar operations across south-central Wisconsin, it hits 94%. Bed pressure becomes its own variable in every decision that follows. The legal response begins at 9:04 a.m. when a Madison-based immigration attorney named David K. files an emergency motion to stay removal.
He is 47, a former assistant U.S. attorney, and he has handled more than 200 removal defenses in the Seventh Circuit. He argues that the 2019 final order was issued in absentia, that Maribel was never properly served notice, and that she has a U.S. citizen minor child whose care arrangements were not adequately considered during the operation. The motion is 43 pages. It cites Directive 11,064.2 by name on page 17. The government's response, filed the same afternoon, takes a different view. It argues that the final order is valid, that the administrative warrant was properly executed, that the minor was released to a qualifying relative within a reasonable window, and that the directive in question is internal guidance, not binding law. On the legal merits, the government is technically correct on the last point.
Internal directives are not statutes. They can be cited. They are harder to enforce. This is the structural feature that advocacy groups will spend the next 3 weeks picking apart. A directive can require documentation. It cannot, on its own, undo a detention that has already happened. The remedy lives elsewhere, in immigration court, on a calendar that runs 16 months deep. The decisive procedural moment arrives on June 28th, 4 days after the operation. A federal immigration judge in Chicago grants a temporary stay of removal pending review of the 2019 Service of Process question. Maribel is not released. She remains at Dodge. The stay only means she will not be put on a plane while the court examines the file. In practical terms, a pause button, not an off switch. That same week, a coalition of 7 advocacy organizations files a formal request with the Department of Homeland Security Office of Inspector General. The request asks for a review of how the Milwaukee Field Office applies Directive 11064.2 in residential operations involving minors. It does not ask for criminal charges. It asks for an audit. The OIG acknowledges receipt on July 2nd. It does not commit to opening a formal investigation. Here is the part most coverage misses. The agents on the ground are not freelancing. They are working a manifest assembled by a Milwaukee Enforcement Planning Unit, which itself receives target lists from a national prioritization system that ranks fugitives by final order status, criminal history, and time since last known address update. Maribel's name appears on the manifest because her address was updated in a state DMV record 3 weeks earlier, when she renewed a driver's license under a state law that permits it. The system did exactly what it was designed to do. It was a bad call. But it was the call the system was built to produce. That is the one piece of narrator opinion this story gets. The rest belongs to the record. The neighbor who filmed the operation, a 47-year-old retired school librarian named Patricia, becomes, briefly, a public figure. She gives 3 television interviews and 1 print interview. She is careful, in every one of them, not to characterize the agents as cruel. She characterizes the moment as a child watching his mother be taken away. She uses that phrase 4 times across 4 interviews. It becomes the headline that runs in the Milwaukee Journal-Sentinel on June 26th. The boy stays with his aunt in Baraboo through the end of June. He is enrolled in a local elementary school for the fall. A child psychologist sees him twice a week. The family's attorney files a separate motion requesting that any future custody decisions involving the child be coordinated through a court-appointed guardian ad litem. The motion is granted on July 9th. It is the first concrete procedural change to come out of the case. The obvious question is whether ICE will change its practices in response to this single incident. The honest answer is that single incidents rarely produce policy change. What produces policy change is the accumulation of incidents that, taken together, become a category. Between January and June of 2026, Wisconsin advocacy groups document 17 residential ICE operations
in which a minor child was present. In 13 of those, the parent was the primary target. In 4, the child was reportedly placed temporarily in agency custody, ranging from 40 minutes to just over 3 hours. The Wisconsin Dells case becomes the 17th. It also becomes the most viewed. By July 15th, the OIG has not announced an investigation. The coalition refiles its request, this time with the 17 documented cases attached as an appendix. The request now runs to 281 pages. It is delivered to the OIG office in Washington by overnight courier. The tracking number is logged. The receipt is signed. Nothing in the public record indicates what happens to the file after that. Maribel's case proceeds in parallel. On July 22nd, the Immigration Court schedules a merits hearing for October. The 2019 Service of Process issue will be the central question.
If the court finds that she was never properly served, the final order can be vacated, and she will be entitled to a new removal proceeding from the beginning. If the court finds the original service was valid, the stay will dissolve, and removal can proceed within 10 days. Her attorney estimates the chance of vacatur at roughly 40%. He tells the family to plan for both outcomes. The bond hearing comes first. On August 4th, an immigration judge sets bond at $12,000. The family does not have $12,000. A community fundraiser, organized through a Wisconsin Dells church, raises the amount in 9 days. Maribel is released from Dodge on August 13th, on the condition that she wear an ankle monitor and check in with ICE every 2 weeks. She returns to Baraboo. She sees her son for the first time in 43 days. The reunion is not filmed. The family asks for privacy. That request, for the first time in this case, is honored. Consider the operational arithmetic from the agency's side. The Wisconsin Dells operation cost an estimated $21,000 in agent hours, vehicle costs, detention bed days, and administrative processing before any legal proceedings. The legal proceedings, projected through the October hearing, will add somewhere between $40,000 and $70,000 more in government attorney time. Total expected cost, roughly $90,000 to detain a laundry worker with no criminal record, generate 9 million views of a live-streamed video, and produce 0 net removals to date. That arithmetic is one reason the OIG request matters, not because it will produce a moral reckoning, because it might produce a budget question. Budget questions are the only kind of question that consistently change how federal agencies operate. By late August, the Milwaukee field office issues an internal memo leaked to a Wisconsin public radio reporter in early September that updates field guidance on residential operations involving minors. The memo does not change the directive. It adds 3 procedural steps: a pre-operation phone call to confirm a care plan, a documented attempt to coordinate with state child welfare in advance, and a supervisor's sign-off on any operation where minors are confirmed present. It is not a policy revolution. It is 3 boxes on a checklist that did not exist before. 3 boxes. That is what this case produced, so far. Return now to that morning, 4:42 a.m. The 3 SUVs rolling into Birchwood Terrace, the child's bicycle leaning against the porch rail, the 8-year-old asleep in race car pajamas, with 43 minutes left before his life changed. The agents on that convoy did their job by the book that existed that morning. The book has since been amended. The amendments will not retroactively undetain anyone. They might, on some future morning, in some future town, mean that a different boy stays asleep through the operation that takes his mother. Or they might not. The book is only as strong as the supervisors who enforce it. The bicycle is still there. The aunt drove it to Baraboo in the back of her sedan on June 27th.
The boy rides it on Saturdays now, around the parking lot of the apartment complex where his aunt lives, while his mother watches from the second-floor balcony, ankle monitor blinking under the cuff of her jeans. That is where the story sits, and the date this script is recorded. A bicycle, a balcony, a pending hearing, a directive with 3 new boxes, and 9 million views of a video that, when it was filmed at 5:11 a.m. on a cold morning in Wisconsin Dells, was only being watched by 84 people. The system worked exactly as it was designed to work. That is the part nobody on either side of the debate wants to say out loud.